by the Oxford Institute for Law, Ethics and Armed Conflict, ELAC, as we know it here in Oxford, to mark the launch of this report, which is called the International Law Protections Against Cyber Operations Targeting the Healthcare Sector. I'm holding it up because we have a very prestigious hard copy here, which I have had the pleasure of reading. And I'd say congratulations to the 4 authors that we are lucky enough to have with us here today. We also have a panel of distinguished experts who I have the pleasure to introduce. So first of all, joining us online, we have Dapo Akande from the Blavatnik School of Government and ELAC. We have Tomohiro Mikanagi from the Japanese Ministry of Foreign Affairs. We have Antonio Coco from the University of Essex and ELAC. And we also have Francesca Bosco from the Cyber Peace Institute. And here in the room with me, we have Shehzad C from GCHQ. We have Talita Dias from Chatham House and ELAC. And we have Priya Urs from St. John College, Oxford and ELAC. And the report being launched today addresses the applicability of international law to cyber operations targeting the healthcare sector, with a particular focus on the law of the use of force, on international human rights law, on the prohibition on intervention, and corollaries of state sovereignty. So several different areas of international law that we're going to delve into today. But we're going to start off with some introductory remarks. Before we go to that, I should say that just to introduce myself, I'm Harriet Moynihan and I'm Associate Fellow in the International Law Programme at Chatham House. We're going to start the introductory remarks with Dapo Akande. Dapo, congratulations on the publication of this report to you and your co-authors, and over to you.
Thank you very much, Harriet, and thanks to everyone who's in attendance or who is watching online. All I'm going to do in setting the scene is really just to place this report in the context of the work that ELAC has been doing on the application of international law to cyberspace. ELAC has been working in this field for the last 3 years. And broadly speaking, ELAC has sought to do 2 things in this area. First of all, ELAC has engaged in specific research on particular areas of international law, and this report that we are launching is in this vein. And then secondly, ELAC has also convened the Oxford process on the application of international law in cyberspace, which I will come to. Let me say a little bit about the research projects that ELAC has been engaged in this area and of which this report forms a part. These research projects have been funded by the Ministry of Foreign Affairs of the Government of Japan, and we are extremely grateful to the Government of Japan for funding this work, and in particular to Tomohiro Mikanagi, who is the legal advisor at the ministry and who joins us today. The first research project that ELAC engaged in this space was looking at the question of whether states have obligations to prevent, to put an end to, or to redress harmful cyber operations which emanate from their jurisdiction. So to what extent do states have an obligation to act with due diligence to take action with regard to those kinds of cyber operations? And that research project was carried out mainly by Talita Dias, who's with you in the room, and Antonio Coco, and which gave rise to a research report that spelled out the different ways in which international law imposes due diligence obligations on states in this regard. The report that we're launching today, International Law Protections Against Cyber Operations Targeting the Healthcare Sector, is a bit different from that, in the sense that rather than looking at a specific question of law, it's actually looking at how international law applies to a particular factual situation that the world has faced and which we will come to. So it's looking at a range of questions of international law in their application to a particular problem. Alongside these pieces of research, ELAC has, over the last 3 years, convened the Oxford process on international law protections in cyberspace. And that has been a related but different strand of work. And in that work, what we've sought to do is to bring together government officials, academics, and other experts with the aim of seeking to clarify the rules of international law as they apply in this area. And one of the things that ELAC has done as part of the Oxford process is, well, I was going to say authored, or at least prepared a set of Oxford statements on particular areas of international law, particular issues of international law, which have then been signed in each case by over 100 experts in the field. And it's actually those Oxford statements that provide the inspiration for the report that we're launching today. Two of those Oxford statements looked in particular at the application of international law to cyber operations targeting the healthcare sector. One of them looked at the issue in general, and the second one looked at cyber operations targeting vaccine research in particular. And in those Oxford statements, we set out a series of propositions of law, which a number of experts were able to come together to agree on. And then in this report, what we've tried to do is to flesh out those rules of law and to try to provide, if you like, a bit more commentary and a bit more depth to the analysis. So that's how we got to where we are today. And let me stop there and hand it back to you, Harriet.
Thank you, Dapo, and thank you for the pivotal work that ELAC is doing in this area, supported, as you mentioned, by the Japanese government. And Tomohiro, it would be very good to go to you now and to hear some of your thoughts on this area and on this report. Over to you.
Thank you, Harriet. Can you hear me? And I thank Dapo and Oxford team for this excellent new report on the healthcare area. I think some of the participants today might be curious about why Japanese government is supporting Oxford University in this area. And let me briefly explain the short history behind this project, if I may. I actually started the project not relating to cyber area. It was probably in 2018 when we started project on the jurisdiction, acceptance of jurisdiction of international court and tribunal. Then I was looking for a new topic. And at that time, UN GGE discussion was kind of stuck in the difference among states, and they could not produce any report in the after the long session. And there was a pessimistic atmosphere surrounding this application of international to cyberspace. And at that time, I was also a fellow to Talita Dias Center in Cambridge, and I organized a workshop in Cambridge, inviting some foreign experts, and discussed, application of international law, including sovereignty or due diligence or the issue of attribution. And I found it really useful to have a wider involvement of international lawyers who have expertise in, I think, basic concept of international law, like sovereignty, intervention, or attribution, and due diligence. So I asked Dapo to have a new successor project to the jurisdiction issue, focusing on due diligence, cyber due diligence. And after that, I think COVID, a pandemic, struck us, and Dapo and your colleagues invented very interesting, online discussion platform called Oxford Process. And I found it very useful to focus on the common grounds rather than the differences about the legal concepts. And you succeeded in issuing several statements, in particular in the area of healthcare. And this project, today's project, I think is a kind of spin-off from this Oxford process, focusing on the particular issue of healthcare and focusing on the four areas of law. I found it the report very useful, especially its focus on the tests to be applied in assessing the violation of international law, like physical effect or reasonable foreseeability. These concepts, I think, are very useful, very simple, clear principles to be applied that could, I hope, provide a basis for the further discussion among international lawyers and government officials. I think now it's a time to focus on what we can agree rather than focusing on the differences. And I hope this report will provide a good basis for our future discussion. Thank you very much. Thank you again for the organizers, and I'm very much looking forward to listening to today's discussion. Thank you.
Thank you, Tomo, and thank you for flagging up some of the principles that we're going to go on to discuss in the report. Francesca, I'd like to turn to you now. It would be very helpful to have a sense of the cyber landscape, I suppose, the broader context in which this report is situated. So over to you to hear a bit more about that.
Thank you so much. Can you hear me well? Great. Thank you so much. And thanks a lot, Dapo, the whole team, and Oxford for the opportunity, actually, to provide the expertise of the Cyber Peace Institute. Specifically, I would say in collecting and analyzing cyber attacks against the healthcare sector, exactly to best kind of like situate also the context when it comes to the cyber threat landscape that we've seen, well, I would say even before the pandemic, but with a focus on, on the pandemic challenges. And then also, I would like to finish with some consideration of what we are still seeing today when it comes, for example, to the conflict in Ukraine. So before providing some data and maybe some remarks on the observations that we can derive from the work that we've been doing, I would like to also give a sense of why the Institute decided to specifically focus on the healthcare sector. And following a little bit the introduction, just to contextualize the Cyber Peace Institute work, the Institute was created specifically to reduce the harm from cyber attacks on people's lives worldwide. And the idea is by analyzing cyber attacks, so we would like to expose not only, let's say, data, but specifically the societal impact and how international laws and norms, and this is why I very much enjoyed I very much enjoyed reading the report and following the Oxford process. So how international laws and norms are being violated, and therefore try to support the overall international community on how to advance responsible behavior. Starting from the very beginning. So what's the impact of cyber attacks on people's lives worldwide? We decided to focus on the most vulnerable. And the most vulnerable really depend on the context that we are living in. And 2020 represented, unfortunately, a sort of like good use case when it comes to the vulnerability of the healthcare sector. And therefore, we started collecting data about the cyber attacks, specifically targeting the healthcare sector, with the aim of producing a report. The report is publicly available. It's called The Playing with Lives, specifically, basically to highlight how cyber attacks against the healthcare sector are ultimately attacks against human beings, against people. One of the recommendations of the report was before being able, let's say, to properly address the complexity of the cyber threat landscape and what the international community can do, we need to understand basically what we are talking about, and we also need to be able to measure, and we need to be able to understand what is the real impact and harm that cyber attacks are causing. There are some factors that make the healthcare sector particularly, let's say, an interesting target, let's put it in this way. First of all, is custodian of sensitive data, including personal data, which has a financial and strategic value. Healthcare services are critical to maintain basically the community, the people's health, because society depends on them. Healthcare is also as a sort of like a center of strategic interstate rivalries, especially since the pandemic, and as we will see also in the context of the current conflict. There are also some sort of like specific vulnerabilities that relates to the healthcare sector. So, for example, to a certain extent, a fragile digital infrastructure that is often very complex, sometimes outdated, and not following the pace, basically, of the digital transformation, for example, when it comes to cybersecurity. Also, what we've seen is that the arsenal of weapons used to target healthcare has been kind of like evolving. So think about, for example, cyber espionage of vaccine research centers, ransomware against the hospitals, disinformation about healthcare professionals linked to opportunities for cyber attacks, and also a sort of like limitation when it comes to technical and human resources, because especially remember during the pandemic, the sector in itself was already under let's say a wide stress because of the emergency. And therefore, there was a sort of like mismatch between the capabilities needed, also when it comes to skills and human resources to counter and to defend from cyber attacks, compared to the reality of what we were seeing in cyberspace. And often a sort of like underinvestment in cybersecurity budget. This is very important to know, because if compared to other sectors, the investment in cybersecurity for the healthcare sector was relatively low. Also, when we talk about the healthcare sector, and this was one of the challenges that we faced since the very beginning, since when we started collecting data, is that healthcare sector is very broad and includes, for example, patient care services, hospitals, clinics, but also, for example, medical manufacturing, pharmaceuticals. So it's a very wide ecosystem. Let me share some of the observation. The platform is publicly available, and it's called the Cyber Incident Tracer Health. And basically in the data collection period, and you can also see in the methodology section also the challenges, let's say, and the limitations that clearly data collection might represent, but still we were able to identify more than 500 incidents in 43 countries. And in terms of like, I would say highlights, so just to share with you some of the, let's say, prevalent observation, we can see the ransomware, as well as for other sectors, but specifically in the healthcare sector, remains a sort of like dominant threat, around the 86% of the documented attack. And I think it's also important to give a sense of what it means, because basically we tried also to understand what it means in practice. It means that on average, every 2 days, a ransomware attack has impacted a healthcare organization, including patient care services of, for example, entire national healthcare networks, or, for example, I would say the second most targeted type of entity, where for example, production of vaccines at pharmaceutical companies. And again, with all the limitation of the fact that this is just, on the attacks that we collected, therefore the real number might be definitely higher. In terms of like actors, we've seen a wide range. So threat actors include the state actors, state-sponsored groups, criminal groups, ideological actors, but also kind of like the sort of like usual suspects. So, for example, cyber criminals. What I think it's interesting is also, and this is also what we are seeing in the conflict in Ukraine, is that there the very much blurring lines. So it's very much difficult to clearly identify often and clearly kind of like relate back to the specific type of actors. And then we've seen also sort of like when it comes to victims, a sort of like a geographical shift. So I would say pre-COVID and still pre-2022, and this is why it's also important to talk about the geopolitical shift. Most of the attacks were focusing on the US, whilst we've seen definitely an increase also, for example, against European entities. And also we've seen notable cases of attacks against the national healthcare systems, which is a sort of like, it reminds us, it brings us back to 2017, unfortunately, to a certain extent. But specifically in 2022, it was a very kind of like remarkable, the case of Costa Rica, where the national healthcare was attacked, impacting more than 1,000 hospitals and clinics.
Francesca, sorry to interrupt you there. I'm very grateful to you for highlighting healthcare as a good use case, and there's so much more that we can say on that, and we would love it if actually you could put in the chat the report that you mentioned that Cyber Peace Institute has produced. I'm just conscious that the second half of this event, we're going to delve into quite a lot of law, and it's a question of just trying to make time for all of that. So if I may just stop you there, but I'm sure that some of the examples that you have very helpfully raised are going to be coming up in this discussion. So I hope that we can bring you back in at that point. And thank you for the context. I'm going to turn now to one of the authors of the report, Priya Urs, who's here with us in the room, who's going to introduce the report to us before we take the deep dive into the various different areas of international law that it covers. So Priya, over to you.
Thanks very much, Harriet. And thank you all so much for coming. So what I'll do now is to just give you a general overview of the report without actually going into any substantive issues. And Francesca has really helpfully outlined the sort of cyber threat landscape that we're looking at and the need to protect the healthcare sector in particular from cyber operations and the particular vulnerability of this sector in this respect, which I think calls for a combination of both preventative measures of cybersecurity, as well as, of course, questions of accountability. And since we take an international law perspective, we're very much focused on the latter in looking at whether the various kinds of cyber operations against the healthcare sector constitute breaches of international law. So when addressing the different rules and regimes of international law, we're obviously guided very much by the factual context that we're looking at. And so we start by examining the different kinds of cyber operations that we actually see in the context of healthcare. And in fact, the work of the Cyber Peace Institute has been immensely helpful in this regard. And we adopt some of the terminologies and distinctions that they make as well, which I'll talk about. And so we focus very much on the particular risks to human life and human health that arise in this context. In doing so, we adopt quite a wide construction of healthcare. So the report is concerned not just with hospitals and other healthcare providers, but also pharmaceutical companies, research institutions involved in the development of medicines, medical technologies, suppliers, also state institutions that are involved in one way or another in protecting public health or monitoring, etc. At the same time, of course, while taking this very wide lens, some choices needed to be made. And so the report is focused on the rules and regimes that apply in peacetime, which is to say we don't address the law of armed conflict or international humanitarian law. So as Harriet pointed out at the beginning, the report addresses a few different areas. And we have 4 substantive chapters in which we address first, the law on the use of force, second, the customary prohibition of intervention in the affairs of other states, third, any other conduct that might be prohibited as a consequence of a state sovereignty, and finally, international human rights law. These are, of course, all rules that bind states. And so in many cases, the requirement of attribution will need to be met. This is something that we don't actually go into in the report. And so instead, when examining various factual scenarios, we assume that the requirement of attribution is met. And in terms of their structure, each of these 4 substantive chapters starts by asking the general question whether cyber operations could be addressed by relevant rules and regimes, before then going on to look at the factual context of healthcare and whether different kinds of cyber operations in that context could breach relevant rules. So in terms of taxonomy, we found it useful at many points in the report to create a sort of division amongst different kinds of cyber operations that we see. So we use a 3-fold taxonomy that roughly maps onto what the Cyber Peace Institute has used in their report as well. And the first category addresses a wide range of disruptive cyber operations, including things like ransomware, denial of service attacks, which in one way or another disrupt or interrupt the use of information and communications technologies that are targeted. The second category addresses data breaches generally. So this includes things like the compromise of sensitive data, theft of data, online publication of data, all of which we see in the context of healthcare specifically. And finally, we have a slightly different category as well of information or influence operations, which focuses in particular on disinformation and misinformation. So throughout the report, you will see this sort of taxonomy recurring in the analysis that we make. So I think I'll leave it at that for now, and then we can get into substantive issues. Thanks.
Thank you, Priya. So this is the exciting bit where we start really zooming in on the different parts of the law in the report and give you a chance to actually raise questions to the authors here or to make comments. And we're going to start with the law on the use of force. And we're going to go back to Priya, who is the author of this section, actually, to give us an overview, first of all, just of what the report has to say on that, some important points, which I think will be very interesting to discuss. And you're going to have a chance to either raise your hand if you have a question if you're in the room. But if you're online, then you go to the chat function on Zoom and you can type questions there, and you can start typing while Priya's speaking if you like. So do put your thinking caps on, and we'll be glad to hear from you in a minute. Priya, over to you.
Thank you. So this part of the report addresses two questions. The first is whether cyber operations against the healthcare sector could constitute a violation of the prohibition on the use of force. And then the second part goes on to look at whether these operations could also constitute perhaps an armed attack, giving rise to a right of self-defense by the targeted state. So in principle, the applicability of the law on the use of force to cyber operations is not really problematic. I think there's now wide agreement that if cyber operations cause effects comparable to those caused by conventional weapons, then they might be able to constitute a breach of the prohibition on the use of force. And perhaps also, depending on their scale and effects, they might also, in principle, be able to constitute an armed attack, giving rise to a right of self-defense. And the relevant effects that we're talking about here include things like causing death, physical injury, destruction. And of course, these are also the kinds of effects that we are concerned about in the context of healthcare. So whether there has been a breach of the prohibition on the use of force depends not necessarily on a state engaging in certain conduct, but on causing relevant effects. And what we find in the report is that this effects-based approach does raise some difficult questions. And one of the questions that we find hasn't really been addressed squarely in the literature to date is the need for a causal standard with which to assess the relevance of various effects. And so this is something that we go into in some detail, but of course, further research in this area is necessary. So to just give you a typical example, the case of a ransomware attack against a hospital, which suspends access to, say, patient medical records or even the use of medical devices, which then prevents the hospital from continuing to provide treatment or even taking on new patients. Could we say that these physical effects could be used to qualify the ransomware attack as a use of force? Now, in this context, it might be quite easy for us to say, yes, that's not a problematic characterization, but other cases might become more difficult. So if we look at the case, say, of a cyber operation that interferes with the clinical trial of a life-saving medication, would we also be able to link any potential physical effects of that medication not then having been approved by a regulatory body and actually having been rolled out to the public? Could those kinds of effects actually be said to be the result of the cyber operation? And of course, there's the even more difficult case of, let's say, a disinformation campaign, as we saw during the pandemic, which prevents or causes individuals to refuse life-saving vaccines. So whether such operations violate the prohibition on the use of force depends on the causal standard that we adopt. So if we use a strict standard that requires a direct link or a direct causal nexus with the effects, these kinds of indirect effects would not necessarily qualify such cyber operations as use of force. And looking at the various possibilities in the report, what we conclude is that a standard of reasonable foreseeability of effects is probably the most appropriate in this context. That said, we do try to qualify this standard in various ways to avoid it being sort of over-inclusive. So for example, we do include in the report a requirement that the effects actually manifest. So there does need to be some death or physical injury or destruction for such an operation to actually constitute a use of force. And of course, the question of causation also arises when we talk about an armed attack. It even comes up in other chapters of the report as well. So this is something I think that is an overarching theme across the different areas that we address. So what does all this imply for the specific kinds of cyber operations that we're seeing against healthcare? I think when we think about the three different categories, disruptive cyber operations are probably the most likely to constitute a prohibited use of force, particularly where they directly target computer systems that are used to provide healthcare to individuals, so hospitals and other healthcare providers. But this need not be exclusively the case, because when we use a standard of reasonable foreseeability, we could also look at other examples where, say, a cyber operation targets the production of a life-saving medicine, or even supply chains, for instance. So the standard of reasonable foreseeability, where these effects actually manifest, allows us to say that a wider range of cyber operations that disrupt the provision of healthcare could be unlawful. I think what's slightly more difficult is the latter two categories. When we talk about data breaches and information operations, it's not necessarily the case that these kinds of operations interrupt the continued provision of healthcare to individuals. And so it's more difficult to make the case that they might constitute a use of force. And then, of course, even more so in the case of an armed attack. So yeah, just to sum up, I think one of the difficulties with characterizing various cyber operations against healthcare as unlawful uses of force is that the requirements for use of force might not be met. And it seems as if disruptive cyber operations might be the best candidate for actually including within such a characterization to the exclusion of many other kinds of cyber operations. That's it for me, but yeah, I look forward to the discussion.
Thank you, Priya. Thanks for pulling out some of the important analysis you have in the report on causation, which is somewhat neglected, I think, in the literature so far on cyber and international law. But as you said, because of the indirect effects in this case, it's particularly important. And you pull out the proposed test of reasonable foreseeability of effects. So I'm going to open it up now to questions or comments. As I said, if anybody in the room here would like to comment or raise a question, do put your hand up. For those of you online, simply type your question into the chat or just indicate if you'd like to say something, and I'll go to you as well. We don't have too long because we need to make time for the other areas of law, but it'd be good to have a sort of 10-minute discussion now on this. And I can see we have a question from the room. Svetlina, over to you.
First of all, congratulations and thank you for producing such a helpful report to all of the authors. I think in addition to the cyberspace context, this just generally makes a really important contribution to our understanding of these rules in a general context. But I have a question about two scenarios which are briefly touched on in the report. They're in many ways the flip side of one another. One of them is when one unintentionally causes the effects that you describe. So to what extent is hostile intent an element of the prohibition of the use of force? And on the other side of this, what about actually having hostile intent, but not causing, because of incompetence or some other reason, the effects that you desire to produce? I know that in the report you speak about attempted use of force or even a threat of use of force, but I was wondering whether each of those elements could be fitted within the prohibition.
Thank you. Priya, do you want to pick those up now and perhaps outline? I don't know if we could hear the question online, so just if you could outline the two questions at the beginning, that would be great.
Yeah, sure. Thanks, Svetlina. Well, both really important, I think, scenarios that we need to think about, and in many ways, the more difficult cases that we need to think about as well. The approach that we take to hostile intent is that it's not strictly a requirement. And I think the reasoning behind that was that when we use an effects-based approach, in any event, intent would be sort of evidenced by the effects that we're seeing. It's very difficult, I think, to evidence intent in any other way. So we would sort of infer intent from the kinds of effects that we actually see taking place. That said, I think they're not reasonable foreseeability and a requirement of hostile intent don't necessarily pull in different directions. I mean, there is some literature that suggests that a standard of reasonable foreseeability is a presumption as to intent. So, I think there are ways to reconcile them. So I think in the first example, where there isn't intent, but we do see relevant effects manifesting, if we use a standard of reasonable foreseeability, it would be quite a different, more objective assessment, I suppose. This is not to say that that includes everything, right? A reasonable foreseeability doesn't require infinite caution. So I think there will be limits based on, say, other potential intervening causes. So if we look at WannaCry, for example, it may not have been reasonably foreseeable, depending, obviously on the specific facts, that healthcare would be specifically affected by that cyber operation, which obviously had effects across different areas and sectors. So that's, I think, one way to think about that kind of scenario. The opposite situation, I think, is in some ways more difficult, the question of whether the effects actually need to manifest. So does a potential use of force actually need to succeed to be so qualified? And I think this is something that we really grappled with. And I don't know, at least to my knowledge, that there is a very clear answer in the literature on the law on the use of force generally. And it may just be that in such cases, the states that are the target of these potential uses of force might not necessarily be willing to call it a use of force. It may be that they describe it as a violation of sovereignty, for example. So I do think that's a more difficult scenario. In a way, the report couldn't really, I think, resolve all of the issues around the use of force. And so we had to make some decisions as to, what we can delve into and what we can't. And so the approach that we took on the use of force was to say, well, let's at least require that the effects have actually taken place as opposed to not have taken place, for the purpose of looking at the kinds of cases that we're examining. But yeah, I suppose the short answer is I don't think there's a very easy answer to that question. And I think arguments can be made both ways. But if we do employ reasonable foreseeability as a test, then that is already wider than a test that would only use sort of direct or immediate effects. And so if we do have this wider effect, we will perhaps need to think about ways to restrict it as well. And this could be, one way to do that. I hope that answers the question.
Thanks, Priya. I think we have got time for another question or comment if anyone would like to intervene. Dapo, I know you're an expert in this area. Be interested in your thoughts.
Sorry, who did you say, Harriet?
I said you.
Sorry about that. Yeah, just to come back to this intent question. It wasn't something that that was covered in the report, but you can separate out two things in the question that was posed. So one is the question of whether you intend to use force. And then the second is the question of whether you intend to use force against this particular state. And this issue of whether you intend to use force against this particular state is one that might be relevant in the cyber context, where you have an operation, as we see has happened in several cases, that may be directed against one thing, but then it has significant spillover effects. In other words, it goes into sort of different countries and affects areas that perhaps were not intended from the beginning. And this is actually very similar to something that the International Court of Justice considered in the oil platforms case. There it was the issue of laying of mines. And the question was whether or not this was an armed attack against the US. And in that particular case, the court appeared to suggest that you needed to consider whether the attack was directed against that particular state. This is in the armed attack context, not exactly the use of force context. But the court did suggest that you needed an intent to attack that particular state for it to be considered an armed attack, which would give rise to the right of self-defense. Now, that's one approach. Another approach actually would be one that says, look, the intention doesn't really go to the question of whether it's a use of force, or doesn't go to the question of whether it's an armed attack. The question of intent actually goes more to the question of necessity in a self-defense context. In other words, you look at intent more for the aspect of looking at whether or not it is necessary actually to respond with force. And so you might say that, look, what matters for the purposes of whether it's a use of force or an armed attack are the effects, and that's the end of it. But intent is not irrelevant. Intent comes in, though, when you're thinking about how to respond to that and whether it's necessary to respond in particular ways.
Thanks, Dapo. And there's so much more we could say about the use of force in this context, and I would recommend very much reading the section on it in the report. But we're going to move on now to make time to discuss the prohibition on intervention and corollaries of state sovereignty. We're very lucky to have with us to introduce that section Shehzad, who's here in the room with us. Shehzad's going to speak for about 10 minutes on those, and then Priya, who has been working very hard and is also the author of this section, is going to take some questions. So again, do think of questions as you're hearing Shehzad talk about this issue. Over to you, Shehzad.
Thank you, Harriet, and thank you so much for inviting me to speak at the launch of this excellent report. And excellent for a number of reasons: the depth of the research, the breadth of the ground that you've covered, and the diversity of the sources that you've used. And I'm especially pleased to be covering this section of the publication because it's an area of international law that the UK has played a significant part in developing over the decades, both generally as well as in the cyber context, through two speeches delivered by the Attorney General of England and Wales in 2018 and 2022, both referenced in the report, and the UNGGE statement that was published in between. And the focus on the healthcare sector is especially welcome too. The UK has had its own experience in the space with the WannaCry ransomware incident in 2017, and at the start of the pandemic in 2020, the National Cybersecurity Centre, which is part of GCHQ, stated that protection of healthcare infrastructure was its #1 priority. And more generally, the UK has consistently made clear in its public statements that cyber operations to disrupt essential medical services can amount to an internationally wrongful act. So I'm going to use my allotted time to cover 4 topics relating to the non-intervention principle, and then make a broader point relating to sovereignty. So kicking off with non-intervention, I want to focus first on scope, and second, whether an attempted action which is ultimately unsuccessful can nonetheless constitute a breach of the non-intervention principle. Third, whether the test for a prohibited intervention includes any mental elements such as intent or purpose. And by way of happy coincidence, both of these areas engage Svetlina's question in context of the use of force that we just discussed. And finally, the extent to which an action deprives a state of control or choice, whether that can potentially constitute coercion. So first, the question of scope. Now, the ICJ in the Nicaragua case said that the principle of non-intervention, quoting here, forbids all states or groups of states to intervene directly or indirectly in the internal or external affairs of other states. And a prohibited intervention must accordingly be one bearing on matters in which each state is permitted by the principle of state sovereignty to decide freely. Now, in my view, the report correctly calls into question the view that the prohibition on intervention doesn't apply to subjects on which states have undertaken international obligations. And I also agree that references to the domaine reservé, a term that we see in many published state positions, are ultimately unhelpful. As the report recognizes, this is a term that began life as a label to delimit those matters beyond the institutional competence of the League of Nations. So it's confusing the way in which it's become part of the discussion on the non-intervention principle, even though the ICJ hasn't referenced this term itself when discussing non-intervention. And I think the ICJ puts it best when it held that the non-intervention principle protects only those matters on which each state is permitted by the principle of state sovereignty to decide freely. So then turning to the issue of whether an attempted cyber operation, which is unsuccessful, can nonetheless constitute a breach of the non-intervention principle. This is a question on which the UK hasn't publicly expressed a view. So in 2022, the Attorney General in her speech at Chatham House did state that, and I'm quoting now, we should be ready to consider whether disruptive cyber behaviors are coercive, even where it might not be possible to point to a specific course of conduct which a state has been forced into or prevented from taking. Now, the arguments that are set out in this report set out one well-researched case for why states might in the future go further. And in particular, the paper draws attention to some potentially important language around attempts in UN General Assembly resolutions. The paper also makes the compelling policy argument that a perpetrator state shouldn't be discharged of any liability simply by virtue of some deficiency on their part, or the conduct of the targeted state in repelling the intervention, for example, through the efficacy of its defensive capability. The paper gives us real food for thought on this point. And as the paper rightly notes, states have set out a range of views on this issue, and it remains very topical. Just a few weeks ago, just after this report was published, the General Counsel of the US Department of Defense spoke on this very point, stating that, and I'm quoting again, requiring coercion to actually produce the desired effect could have paradoxical results. It may disadvantage states that are better able to deflect or endure coercive acts, and it could reward states whose attempted intervention fails. Now, the issue of attempted actions is closely linked to the next issue I wanted to discuss, which is the intent of the targeting state. Now, the report dismisses the suggestion that the intent of the targeting state should be part of the assessment of whether a state's conduct can be said to be coercive. Again, states have expressed a variety of views on this issue. And again, the UK hasn't expressly spoken to it in its recent cyber statements, although the Attorney General did, in her speech last year, state that, quote, all relevant circumstances need to be considered. So the UK is not, in fact, ruling out an intent requirement. And it's worth noting that the Tallinn Manual 2.0 has also recorded a range of views between participants on this intent or purpose requirement. And then there's a separate question here with regards to what is meant by intent in the first place. How far does it cover certain types of indirect intent or even reckless risk-taking? We know that there are definitions in international law that are pretty broad in this regard. Article 30 of the Rome Statute is a case in point that differentiates between that intent requirement and an indirect intent. And then finally, on the non-intervention principle, and specifically coercion, there's a question of whether coercion can equate to a loss of control over a sovereign choice in addition to forcing a change in behavior. The control model, as Marko Milanovic refers to it in his upcoming paper on coercion. Now, the UK takes the same view as the report in this respect. We basically say that as a matter of plain English, if you are stopped from exercising your autonomy, then you are being coerced. Other states, such as New Zealand, Australia, and Canada, have also essentially taken the same approach in their public statements. And the English courts have agreed with the formulation that's used in Oppenheim, namely that, quote, the interference must be forcible, dictatorial, or otherwise coercive, in effect depriving the state intervened against of control over the matter in question. And certainly as far back as 1984, a now declassified Foreign Office memo describes intervention as wrongful where it is, quote, calculated to deprive that state of control of the matter in question. So this isn't a new UK position that's being set out. So finally, then moving on to the question of sovereignty, and like the rest of the paper, Chapter 4 is thoroughly researched and sets out the wide range of state positions and academic writing. And the UK's position on territorial sovereignty has been articulated a number of times in identical terms in 2018, 21, and 22. In short, the UK's position is that we are not persuaded that we can extrapolate from the principle of sovereignty a specific additional prohibition for cyber conduct beyond that of non-intervention. And while this report explicitly takes a deductive approach, you won't be surprised to hear me as a government lawyer extolling the virtues of the importance of state practice and opinio juris. And significant in my view that therefore that the vast majority of states have not opined on this issue, even if I must acknowledge that of the ones that have, only the UK has expressly taken the position that it has. However, and I've said this before on the record, the differences between the UK and other states when it comes to what is actually prohibited shouldn't be overstated. Brazil, if I can use that example, Talita next to me, at one end of the spectrum takes the view that interception of communications overseas is a violation of sovereignty. On the other hand, New Zealand interprets the rule of sovereignty as permitting certain cyber operations with minimally destructive effects. And Canada takes a similar approach, that there is a de minimis threshold before an act can be considered internationally wrongful. So the UK's position is closer to that of New Zealand and Canada than New Zealand and Canada's position is to Brazil. So the content of any sovereignty rule is far from settled, even among those states that advocate for its existence. And we also need to consider state practice. As the publication notes, Iran, to take one example, is among a handful of states that says that any penetration of a computer system, even if it doesn't cause harm, would constitute an internationally wrongful act. Yet the National Cyber Security Center assesses that Iran is an aggressive and capable cyber actor. So it's worth questioning whether Iran's practices in cyberspace accord with its official position. So I would contend, therefore, that there clearly remains a disagreement about the content of any such rule, and that the focus should remain on the types of activity that constitute an internationally wrongful act. For example, with respect to healthcare, whatever route is taken to arrive at that destination. And I'll end there with that final endorsement of this paper as a hugely valuable contribution to this debate. Thank you.
Thank you, Shehzad. There's a lot there, a lot to reflect on. That was very helpful indeed. And I think it does highlight the great work that the report does in going into these areas and actually coming up with some quite fresh analysis on concepts that haven't been dug into before, particularly like, as Shehzad said, what you've done with your discussion, Priya, around the domain reserve, which is something that's obviously very prominent in the Tallinn Manual and has been adopted, I think, a lot in the academic literature and by some states in their analysis. But rather than sort of, I think, blindly questioning it, blindly following it, it's good to sort of consider it further, and the report, I think, does a great job of that. It's time now to open it up to questions and comments. As I said, there are a lot of points that I think Shehzad put out there that you might want to think about: intent, scope, whether or not an attempted intervention suffices, and then the issue of control, and the way that we, I suppose, define coercion, which is at the nub of intervention. Then, of course, issues around sovereignty, and as Shehzad said, the very different approaches that states take on this issue. So do type away in the chat if you have anything that you would like to comment on or ask questions of Priya. And also do raise your hand if you're here in the room, because we'd love to hear from you. And otherwise, I'm going to have to start waffling on myself about this subject because I enjoy it very much. I did have a question. I'm not supposed to be asking questions to Shehzad, but I did want to ask about the English court case that you mentioned, where you mentioned Oppenheim, and I hadn't come across that. So do you have that to hand at all? Do you recall which one that was?
So I think it was a case in relation to Venezuela, wasn't it? Yeah, I think you have an audience colleague nodding
that's
to me.
Useful.
And it was, it's recent enough to only have been in the most recent edition of Oppenheim, the 9th edition, not previous to that. But it was precisely this, I think, in relation possibly to, or the context, I think, was recognition of the government. So yeah, it was,
okay,
it was that context.
Priya, did you want to talk a bit more about the domaine reservé point? It's something, as I say, it's not new, but it's quite unusual compared to most of the academic literature. And if you could just perhaps explain, what was the basis for you taking that view, moving away from domaine reservé?
Yeah, thanks. Well, actually, the basis for me taking that view was your report on non-intervention and sovereignty, which got me thinking about the domaine reservé in a bit more detail. But I think, so maybe just to very quickly summarize, a lot of the literature, certainly on cyber and international law, but also some of the general literature on the prohibition of intervention, talks about the domaine reservé as a principle that limits the scope of the prohibition of intervention. And the way that the argument goes is to say that if a matter is the subject of a state's international obligations, then it no longer falls within the protection of the prohibition of intervention. And there are a number of commentators who take this view. Harriet mentioned, I think the Tallinn Manual as well discusses the domaine reservé in this context of non-intervention. But going back to the original sources, which was actually a case at the Permanent Court of International Justice, it doesn't seem that this was necessarily the context in which that principle was developed. It was a very different context of determining whether a particular matter should be addressed under international law or under the domestic law of a state. And this was specifically in relation to a provision of the Covenant of the League of Nations. There were a couple of cases later under the UN Charter as well. But I think the reason I started thinking about it was because those cases didn't seem to have anything to do with the prohibition of intervention. And it also didn't seem to me from a principled point of view that that needs necessarily to be the case. Just because a state takes on certain international obligations, it doesn't mean that it's sort of waiving the application in respect of those obligations of the prohibition of intervention. And at the same time, I think there is some literature that suggests that because states retain a lot of discretion often in the way that they actually implement their international obligations, that discretion should be equally protected from intervention by other states. With all this being said, I think the one sort of disclaimer to add, and the objection that I think is validly raised, is when it comes to countermeasures. But obviously, states taking countermeasures do so under specific conditions and with specific requirements imposed upon them in doing so. So I think the availability of countermeasures when a state breaches its obligations is a very specific situation. And this isn't to say that the prohibition of intervention shouldn't generally apply, even when states have undertaken international obligations. So I think this is sort of the view that we try to detail in the report that is somewhat different.
Thank you. Any questions in the room or on the chat? Because I really don't want to abuse my privilege as chair. So I'd rather anyone use their chance to jump in if they wished. Harry, over to you.
Thank you. Just a question for Priya, which is, I'd really be interested in your reflections on how the healthcare sector in particular goes to the consideration of the scope of the state's freedom of choice, given that healthcare in particular is provided in different states in different ways. Sometimes it's a wholly public function, other times it's mostly the private sector, and how you considered the particular aspect of that sector and that public-private divide.
Thank you. Yeah, that's a good point. I think something that is very specific to the healthcare sector in particular. So the way that we approached it is not necessarily to make a distinction on that basis, but again, it will depend very much on the facts. So even if we take a case of a state where healthcare is highly privatized, for example, like very different from let's say the NHS, I think the case could still be made that the state's regulation of healthcare, or even the state's obligations under international law with respect to healthcare, with respect to the right to health, for example, are ultimately being implemented through private actors. So the state, you could make a case, I think, to say that the state still retains sort of an overarching choice or policy. So it doesn't need to be a very specific choice or policy that the state has with respect to healthcare, in the sense of actually, let's say, administering hospitals. I think you could still make a case, even in a privatized context, to say that the state still has a choice or a role in implementation of healthcare, even when we're talking about, say, private hospitals. So it might be that the case is slightly more difficult to make, but I don't think that it necessarily excludes the application in a privatized sort of context, if that helps. I think maybe a slightly different issue would be in the context of where we're talking about a state or government function. And in that, I don't think that's necessarily how we need to apply the prohibition of intervention, but it does come up in some other approaches that have been taken to sovereignty, in some of the literature. And I think then we would need to really spell out what we see as a government function or the exercise in that sense.
Thanks, Priya. And you mentioned at the start, when you were introducing the report, the sort of structure that you have, which is looking at disruptive cyber operations, and then looking at kind of compromise or theft of data, and then looking at disinformation and misinformation. So different types of I suppose, malicious cyber operations. And we can see in the context of disruptive cyber operations, and the UK government actually have mentioned this, that there can be quite good examples of intervention that are coercive, for example, disrupting the supply of vaccines, and I think causing hospital computers to malfunction, preventing the supply of power. But when it comes to the other categories, and we're looking at coercion there, I think the report talks about the application to the compromise and theft of data and says normally that wouldn't be coercive, but there was one example where you say it might be, and it'd be interesting to hear your thoughts on that.
Yeah, so you're right. The general position that we take is that data breaches will not normally constitute prohibited intervention. The one sort of exceptional case that we discussed was, coming up very much out of the pandemic and the development of COVID-19 vaccines, this idea of a data breach of systems used for a clinical trial. So we know that the way clinical trials run is for there to be two separate groups without the individuals involved in the program actually knowing to which group they belong. And so there's the treatment group and the control group. And so in this context, if there is a data breach that, it doesn't necessarily need to be that the data is published online as such, but just the access itself might call into question the validity of the clinical trial so as to prevent regulatory approval of the trial. And so it could be in those kinds of cases where we could make a case to say that that's coercive because it prevents the state from actually carrying out the clinical trial and therefore approving a potentially life-saving vaccine. So I think, again, it would depend very much on the facts, but this is, I think, one of the scenarios that we saw as potentially falling within the prohibition of intervention. I think Miles had a question.
Miles, over to you.
Thanks, Harriet, and congratulations to all of you. So if attempts are included, I wonder if you could say a little bit about remedy in those cases. Are you thinking about guarantees of non-repetition? Is there something creative about attempted interventions that fail that might be addressed through remedies or responsibility?
Well, I suppose it would be different in that you don't necessarily have the question of reparation, but there could still be guarantees and assurances of non-repetition in that context. I'm not sure what more would necessarily come out of it, but yeah, we didn't really look into remedies too much.
Well, one of the things that the report does is provoke a lot more questions, and as you said about causation, it's a real springboard for further research and further work. So that's one of the areas that could spring from this. We're going to move on now to the final area that the report looks at, the final area of law, which is international human rights law. And the report actually pulls out 4 different human rights that are relevant to cyber operations targeting the healthcare sector: the right to life, the right to privacy, the right to health, and the right to freedom of expression. And we're lucky enough to have both of the authors of this section here with us, Antonia joining us online and Talita here in person. And Antonia is going to set the scene for us by speaking for a few minutes about this section. And then as before, we're going to open it up to questions and comments. So Antonio, over to you.
Thank you, Harriet. And thank you to Talita, Priya, and Dapo for working so well on this report with me. So about this section on international human rights law and the protection of human rights that are implicated when cyber operations target the healthcare sector, I just want to say why we analyze this. And the reason is pretty self-explanatory. The provision of healthcare concerns efforts to tend to the needs of human beings. So it is only natural that when we analyze healthcare provision and obstacles to the effective provision of healthcare, several human rights are involved, and particularly internationally protected human rights. So we tried to do a little overview of the rights that we thought would be most relevant for situations in which healthcare is under attack and under threat by cyber means. And the first right that came to our attention is, as you were saying, the right to life. This is obvious why. Very often the life of people is under care in healthcare facilities, and cyber operations that affect the possibility for healthcare facilities to operate properly will threaten very often the right to life or the right to physical integrity. The right to health is also involved for obvious reasons. The provision of healthcare is key, crucial to attaining the highest possible standard of health, which is the aim of international law protections of the right to health. But besides these two kind of obvious rights, we wanted to also analyze other rights that are implicated by the modern threats that the cyber means pose. The first of them being the right to privacy. We know that the provision of healthcare relies on the collection and storage of vast amounts of data. These data, back in the day, used to be collected in paper, and now it is entirely digital. So the protection of data collected for the provision of healthcare is fundamental to protect individuals' rights to privacy, especially considering that the kind of information that those data concern is very personal, very sensitive, and demands a higher level of protection. The fourth right that we analyzed is the right to freedom of expression and information. And the reason is quite simple too. Access to healthcare depends on the ability to obtain relevant information about the treatments, about the facilities, about the providers. And the provision of healthcare, the effective provision of healthcare, depends on stakeholders' right to provide information without interference, information that is accurate and reliable and corresponding to scientific standards. One thing that we noticed when analyzing these four rights is that looking at them individually would not give us a full picture. These rights are interdependent. Protecting one helps protecting the other ones. Measures that states have to put in place to protect these rights, or cyber operations that will harm these rights, would harm usually more than one at the same time, and the measures will need to protect more than one at the same time. So they really come as a whole rather than for individual components. We try to present a picture that is the most complete possible, but of course, there are many other dimensions that we didn't deal with. When carrying out our analysis, the framework that we adopted was the classic framework of international law, looking at summary international law, international treaties, and regional treaties. And we encountered some challenges in applying this legal framework, of course, that are somehow common when analyzing facts of life through the lenses of international human rights law. The most important challenge being the issue of understanding the scope of obligations depending on the extent of the jurisdiction of the duty bearer. The debate on the extent of extraterritorial jurisdiction for the protection of human rights was key to our analysis. And of course, another challenge was the issue of the secrecy of cyber operations, or the lack of information about the author of cyber operations, that very often makes it difficult to understand who is the duty bearer and when obligations under international human rights law are triggered. What is the result of our analysis? Without going into specific rights, as it is obvious in the framework of international human rights law, we found out that states bear several obligations for the safeguard of human rights in the context of healthcare provision when attacked by cyber means. And these obligations can be divided broadly in two categories: negative obligations. So states shoulder an obligation to refrain from engaging in cyber operations that directly or indirectly violate human rights. These operations have been mentioned in brief by my colleagues before, include disruptive operations, data breaches, and influence operations, including mis- and disinformation. And in addition, there are positive obligations to actively protect the human rights of people against threats or harms that are posed by a variety of agents, by cyber means, regarding the provision of healthcare. There are also positive obligations to ensure that those rights are enjoyed by the right holders, which means duties for states to create the conditions for the full enjoyment of the right, for example, by maintaining a high level of cybersecurity when it comes to the provision of healthcare and having an adequate legal framework to address cyber threats to healthcare. This feeds into the work that Talita and I had been doing on due diligence, of course, which is the standard of conduct by which compliance with these positive obligations is assessed. So in a sense, this study on international human rights law was a continuation and a confirmation of the fact that states shoulder many obligations, obligations that are to be interpreted flexibly, but obligations that are to be interpreted flexibly with an aim that is very clear, and that's the aim of safeguarding the right to life, the right to health, the right to privacy, the right to freedom of expression and information of people that seek healthcare and need healthcare. Thank you.
Thank you, Antonio, and thank you for highlighting the interlinkage between the different rights. And obviously the report goes into a lot more detail about some of the points you're making about positive obligations as well as negative obligations. I think one of the things that the report pulls up is some of the controversies around these issues as well. There's the obvious one about extraterritoriality and the fact that's interpreted differently by some states and human rights bodies, commentators. You mentioned about the ambit of states' obligations, and there are debates around, I suppose, due diligence and the standard of conduct. Perhaps we could put a link in the chat to the excellent report that that Oxford Process has produced on that, you and Talita. And then I think there are a number of other challenges, but before we get onto those, I'd like to give you, the audience, the chance to raise your own questions and make comments. So there's anyone here either in the room or online who wants to type into the chat. I know that Talita, who has co-authored this section with Antonio, is here to make comments herself. And I can't see any hands raised or comments at the moment, Talita. So I would be interested, certainly, in hearing your thoughts on a couple of things. So one is this question about the ambit of states' positive obligations, which comes into quite a lot of the sections, quite a lot of the rights that you've written about. And another is about, you, I know, have written about freedom of expression. And as part of that, you've talked about the positive obligation on states to try to regulate, well, online harm, I suppose. But we've seen in practice, many governments are finding that very difficult. And here in the UK, we have the Online Safety Bill. In the EU, we have Digital Services Act. And as far as it comes to disinformation, it's even harder. So I suppose it goes to this question of the ambit of a state's positive obligations. So any thoughts on the challenges, I suppose, of this area would be very welcome. Thank you.
Thanks so much, Harriet. Thank you. Thanks, everyone, for being here. And thanks to Antonio for taking over the presentation on our chapter. So on the ambit of positive human rights obligations. So as Antonio mentioned, These obligations are obligations to protect human rights, and they are not obligations to achieve a particular result in the sense of successfully protecting the human right or human rights in question. So, and this is what we refer to when we say that these obligations are obligations of due diligence. So these are obligations to attempt or to try and protect the rights in question as far as possible. And this standard of conduct, or this sort of like type of obligation, also applies to, or is also true of, obligations to ensure human rights, which is true of, for example, social, economic, and cultural rights, like the right to health. So when we talk about these kinds of positive obligations or obligations of due diligence, and these are obligations that are quite flexible, right? Because again, they don't require the state to actually ensure a particular result. And so this means that states enjoy a wide margin of discretion and flexibility when implementing or fulfilling these protective obligations. And so the obligations are first and foremost dependent on a state's level of knowledge, which could be actual knowledge or constructive knowledge. And that shapes in a way the scope of the obligation, and also the kinds of measures that the state will be required to take in each and every case. And there's also the question of the capacity or capability of the state of actually protecting human rights or implementing this obligation, fulfilling this obligation. And so as any due diligence obligation, the duty to protect human rights depends on the ability of states to, and when I say ability or capability, I refer to all kinds of capacity that affect a state's ability to protect human rights, including its economic or financial ability to do so, human resources, and the proximity between the state and the perpetrators of a certain cyber operation, and so on and so forth. So, so that's another consideration to bear in mind when thinking about positive human rights obligations. And there's also the issue of jurisdiction, right, which you mentioned earlier, which also affects the scope of these obligations. And again, this is a very controversial issue. I won't go into a lot of detail on this, but all to say that the report takes the view that there are different models of extraterritorial jurisdiction, and that's the hot topic really, extraterritorial jurisdiction, meaning the extent to which these obligations apply beyond the state's territory. And the report takes the view that there are different models. For example, extraterritoriality might cover an individual or a particular geographic space, or regulatory control over certain entities. And there's also a more expansive model, which is referred to as the functional model, which applies to a state's control over the enjoyment of human rights. And we take the view that this is the most appropriate model for the digital environment, because today, we certainly do a lot of our lives revolve around the digital environment, and states are able to exercise quite a lot of control and quite a lot of power over our activities because of this dependence that we have on information and communications technology. So we think that this is the more appropriate model for ensuring respect and protection of human rights online. Now, on freedom of expression, that's a very good question, and the reason we included freedom of expression in the report is, as Antonio said, the right. Healthcare depends on human beings being able to access information that is accurate about health, but also the need for individuals to express themselves when there's, for example, a certain issue, when there is a pandemic, for example. Remember at the beginning of the pandemic, clamping down on freedom of expression delayed the response to the virus, right? So that's why freedom of expression is so important in this context. But at the same time, as Antonio rightly said, so there's this need for truthful, accurate health information. At the same time, under international human rights law, the right to express information and to receive information. And we must remember that the right has this dual dimension of expressing one's views, but also receiving information, right? There's this dual individual and societal dimension to the right, because information is a two-way street, right? It's communication. So we have to protect the two dimensions. But so going back to my point, freedom of expression is not just protective of accurate information. And the European Court of Human Rights, for example, has said that explicitly. So it protects even false statements. It protects satire, it protects blasphemy, and all kinds of shocking, very disturbing kinds of information as well. So we find ourselves in this clash between the right of individuals to receive truthful information and the rights of individuals to express whatever kinds of information they want to express. And so here we have to really carefully balance between the two competing considerations. And the way that the international human rights law framework does so is by requiring any limitations, and freedom of expression is not an absolute right. So it is subject to limitations precisely because of these conflicts of rights that might arise. And so the idea really is that whenever we limit information, including false information, we need to observe certain requirements. And these are the requirements that are laid down, for example, in Article 19.3 of the International Covenant on Civil and Political Rights, the requirement of legality to have laws laying out what speech might be limited and what are the sanctioning measures that we adopt for limiting speech. And also, speech can only be limited for a legitimate reason. So if we're going to limit lies or misinformation or disinformation in the healthcare context, we need to find a legitimate reason to do so. And in the healthcare context, that justification is quite clear. It's the protection of health, right? Or the rights of others. And then any limitation on speech needs to be necessary and proportionate to the harm that one is trying to halt or avert or suppress. And so this means that any limitation on speech, even harmful speech, disinformation, misinformation, needs to be well calibrated to the interest that we're trying to protect, healthcare, but also the seriousness of the Speech Act. So we have this framework that allows us to sort of like balance these competing considerations. And one final point I would say is that, as you mentioned, Harriet, there's this urge to adopt legislation, right, on content governance, on content moderation. And here, and a lot of people have talked about the need for the state or states to police the internet, right, because this is the digital public square of today, right? And people talk about that in a very sort of like policy way, rather than a legal way. But the view that we take in the report is that actually legislation is required, first and foremost, because of this requirement of legality, right? To limit freedom of expression, you have to have law, to ground that in law. So this is the first reason why legislation is necessary in this context. But also, going back to my point about the dual nature of freedom of expression, the state has an obligation to protect the right of individuals to both express themselves and to receive information. So again, that calls for legislation, not legislation that tries to censor everything or clamp down on all kinds of speech, but legislation that really tries to calibrate between these different considerations at play.
Thank you. And I guess that's the sort of the dilemma that governments are wrestling with. Francesca, may I come back to you, partly because I know that you put in the chat your report. You put a link there to the fact that this is a very live issue in Ukraine at the moment in terms of healthcare, and you specifically referenced disinformation. So I'd be really interested to hear, I suppose, a real life example of how this is playing out in that kind of context. If you had a minute or two to comment on that. Sorry, Francesca, I think you're on mute.
So what I wanted to say is that as of now, the type of attacks that we've seen to civilian infrastructure in the context of the Ukraine conflict, specifically when it comes to health, are notably basically the victim of attacks from what they would be called the non-state actors. So like, for example, activists. And also notably, we've seen a sort of like rise up in activities against the healthcare sector, specifically in Q1 this year, for example, against Germany, because Germany took a specific stand, specifically in the, when it comes to sending potential help, basically to Ukraine. So it's not necessarily linked to disinformation. The part on disinformation was more about the initial comment from Priya about adding sort of like disinformation as a category of cyber attacks. And this is what basically we observed from the work on healthcare to the work that we're currently doing when it comes to basically monitoring the attacks against civilian infrastructure and specifically the healthcare sector in the context of the Ukraine conflict, because we see indeed how disinformation is definitely playing a role. I just would like to make a very quick comment following on the discussion about freedom of expression and disinformation and harm. As very well noted, that the concept of harm is absolutely key, because for especially when we think about freedom of expression and information in times of crisis, for speech to be subject to limitations is not enough. That is untruthful, as mentioned before, but it must cause significant social harms. And in the COVID-19 context in particular, this would generally be harms, for example, to human health. And I really would like to stress also the kind of like need to consider harm for the individual and harm for society. One of the examples that I have in mind when it comes to COVID specifically is when there were basically dissemination of information about methanol, for example, as a cure for COVID-19, while knowing that the information is false and knowing that the health risk of ingesting, for example, methanol. So you also need to explain basically and to show requiring the proof of a high standard basically of mens rea. I would like to leave with one comment and one challenge, which is still the definition and the measurement of harm is still highly debatable. And so this is one of the challenges that I see also in the current formulation, basically. And this is also where for example, as a cyber peace institute, we are currently working on a methodology to define the harm.
Thank you, Francesca. A good reminder of some of the real life scenarios that are behind this report. And I see that we're coming to an end now. I would like to just make one sort of concluding observation, which I think is that this event has brought out the real value of a sectoral approach to these issues. I think it's been very interesting to take this lens of healthcare, because healthcare is obviously critical infrastructure. And when you layer the pandemic onto that so that you have a global emergency, then it becomes very clear that states have a very kind of important role to play. And when you apply certain rules like intervention, it's almost a good use case, as it was said, it's almost easier in those sort of scenarios. Whereas before we were sort of trying to debate abstract concepts like what is an essential medical facility. So sort of being able to draw, as the report does, on real life examples, very sadly, there are quite a lot of them, of cyber attacks against the healthcare sector. And bearing in mind, as several speakers have said, that the healthcare sector is one heavily dependent now on telemedicine, on online and on the mining of data. And that's the direction of travel generally. I think it was a very good sector to pick. And it's really enabled a lot of sort of granular analysis, which I think could be helpful for all of us, but perhaps particularly for those governments that haven't come out yet with their statements on how they see the law on the application of international law to cyberspace, because as I say, there are a lot of good examples there. And perhaps we could even consider this as a precedent for analysis of other sectors. It would be interesting to see a report in the future, for example, on the law that applies to cyber operations against the energy sector. And we look at examples like colonial pipelines. There's plenty of examples out there. So I think it sets a great precedent. Congratulations again to all the authors. And thank you very much to those of you joining online and to those of you who've participated here in the room as well. So thank you and goodbye.